Visualize opening a letter and discovering that this precious inheritance comes with a surprise bill for an extra $2,000 a month in property taxes. And what if I told you that bill never goes away? Didn't Proposition 19 protect you? You inherited your family home, the one you grew up in, the place where every holiday was celebrated, every milestone marked. This isn't a hypothetical scare tactic. It's a financial nightmare a California family is living through at this very moment. They did what they thought was right. They had a living trust meticulously set up years ago. They believed they were completely protected from Proposition 19 and qualified for the California homeowner exemption. But one single irreversible mistake, a mistake baked into the very trust they relied on, cost them their financial security and their peace of mind. I'm going to show you the exact critical error they made so you can be absolutely certain it never happens to your family. If this is something you're facing right now, subscribe for clear guidance. And no, you don't have to figure this out alone. Because this isn't just about a tax hike, this is about the very real possibility of being forced to sell a home that's been a part of your family for generations. Since the inheritance rules of Prop 19 kicked in on February 2021, the entire landscape has changed. The rules are gone. The strategies that worked for your parents or neighbors for decades, they're now worthless. Even a standard by-the-book living trust is no longer enough to shield you. And the truly terrifying part, the consequences of a mistake are permanent. Once the error is made, once that deadline passes, there is no lawyer, no appeal, and no trust amendment that can turn back the clock. Before we dive deeper into the family's heartbreaking story, you need to understand the fundamental shift that has happened. For decades, California homeowners enjoyed incredible protection thanks to two landmark propositions. First, there was the famous Prop 13 back in '78. It did two amazing things. It capped property tax rates at 1% of the assessed value and severely limited how much the assessed value could increase each year to a maximum of 2%. This is precisely why your parents or grandparents might be paying just a few $1,000s a year in taxes on a home that is now worth millions. It created predictable, affordable home ownership. Then, to protect the next generation, came Prop 58 and 193. These created the parent-child exclusion. This was the golden ticket for legacy planning. It allowed parents to pass their primary home and even up to $1 million of other assessed property value to their children without triggering a reassessment. The kids inherited the house and the cherished super low tax bill that came with it. A living trust was the perfect vehicle to make this transfer happen smoothly and avoid probate court. But Prop 19, which voters narrowly approved in 2020, completely blew up that system. It was primarily marketed as a benefit for seniors, allowing those over 55 to sell their home and transfer their low tax base to a new home anywhere in California. But the funding for this new perk came at a steep price. They completely gutted the parent-child exclusion rules that families had relied on for over 30 years. So here's the new world order in a nutshell. To inherit your parents' low Prop 13 tax bill, you can now only inherit their main home, and this is the absolute non-negotiable part. You, the child, must physically move into that home and make it your primary residence within 1 year of the transfer. If you don't, if you decide to rent it out, keep it as a vacation home, or simply aren't able to move, bam, the property is fully reassessed to its current market value. Your trust doesn't stop it. The second the last parent passes away, the law sees that as a change in ownership, and a revocable trust becomes irrevocable, and the unforgiving Prop 19 clock starts its 1-year countdown. Okay, let's get back to that family. For their privacy, we'll call them the Millers. Their parents, John and Mary, bought a house in a quiet Mission Viejo neighborhood back in the 80s. Thanks to Prop 13, their tax bill was locked in at about $3,000 a year on a home with a low assessed value of around $250,000. John and Mary were diligent planners. They did everything by the book. The old lawyer set up a living trust and named their children, Sarah and David, as equal beneficiaries. The trust language was crystal clear, a common phrase in the thousands of pre-2021 trusts. When both parents are gone, everything, including the house, gets split 50-50 between the kids. Last year, John and Mary passed away within months of each other. The house, long since paid off, and now sitting in a neighborhood where the comparable homes sell for $2.5 million, passed to Sarah and David through the trust. They assumed the trust, which their parents had relied on for 30 years, would protect them from a massive tax hike. They were tragically mistaken. Sarah had built a life for her family out of state, and David had his own home and career an hour's drive away. Neither of them could realistically uproot their lives to move into their childhood home. So they decided to rent it out for a while to cover the upkeep and give themselves time to figure out the next steps. They were grieving and dealing with the immense task of settling their parents' estate. The 1-year anniversary of their mother's passing came and went. 1 month after that anniversary, the letter arrived, an official envelope from the county's assessor's office containing a supplemental tax bill. Their annual property tax wasn't $3,000 anymore. The county had reassessed the home at its current market value of $2.5 million. The new tax bill was over $27,000 a year. That's a permanent $24,000 annual increase, an extra $2,000 every single month. That is a mistake you can't fix because neither Sarah or David made the house their primary residence within the 1-year window. They lost the parent-child exclusion forever. No appeal can fix it. The change in ownership had already occurred. Their parents' death, the strict Prop 19 rules were not met. Their parents' trust, by simple ordering an equal split of 2 children who couldn't live there, had actually guaranteed this financial disaster. The Miller story is heartbreaking, cautionary tale, and it's happening every day in counties across California. But situation is just one of the ways well-meaning families are getting trapped. Here are the 3 more irreversible mistakes even a standard trust won't save you from. Mistake number 1, the equal split trust trap. This is the core of the Miller problem, and it's a time bomb hiding in countless trusts written before February 2021. An old trust might leave one house to 3 children, with instructions to distribute the assets equally. Before Prop 19, this was simple. Now it's a trap. Under the new law, only one of the children needs to move in to claim the tax base exclusion for the property. But what if none of them want to or are able to move? Or more commonly, what if 2 siblings want their inheritance now in cash to pay for college tuition or a down payment on their own home? The old trust becomes a straitjacket. If no one establishes the home as their primary residence within 1 year, the exclusion is gone for everyone forever. If a sibling has a change of heart and wants to move in after the date it's too late. The reassessment is already locked in permanently. An old trust that just says split everything equally offers zero flexibility or solutions. It doesn't grant one child the right to buy out the others, nor does it empower the trustee to creatively swap other assets to make things fair. It just winds the tax bomb down and waits to detonate. Mistake 2, the "I'll just rent it out later" delusion. Many people who are aware of the new rules think they can game the system. They have a clever idea. Okay, simply, I'll inherit the house, move my stuff in, file the paperwork to make it my principal residence, get the low tax base locked in, and then a year or so later, I'll move out and turn it into a rental property. This is a huge and costly misunderstanding of the law. The requirement that the home be your principal residence is not a one-time checkbox you tick. It's an ongoing, continuous requirement. The moment you convert that home into a rental property, you have retroactively violated the terms of the exclusion. The assessor will find out. They monitor things like where mail is delivered, which address is on your driver's license, and whether a homeowner's exemption is still being claimed. Once they discover it's no longer your primary home, the Prop 19 exclusion is terminated. The property will be immediately reassessed to its full market value at the time you inherited it. Plus, any inflationary increases. That low tax bill you thought you had secured, it's gone forever. Another devastating mistake you simply cannot undo. Mistake number 3, thinking the 1 million exclusion is a free pass. This is perhaps the most widely misunderstood part of Prop 19, and it trips up even the families who think they're following all the rules. The name 1 million exclusion is dangerously misleading. It is not an automatic $1 million discount off the home's market value. Here's exactly how it works. An inherited home keeps its old tax value only if the current market value is less than the old assessed value plus $1 million. If it's worth more than that, you get hit with a partial reassessment. Let's break that down and go back to the Millers. Their parents assessed value, the factored base year value was $250,000. So the magic number of their maximum inclusion, but the house was worth $2.5 million at the time of inheritance. Even if one of the kids had moved in and filled out the paperwork correctly, it would not have been a simple transfer of the old tax bill. The property would have been partially reassessed. The new taxable value would be calculated by taking the amount over that $1.25 million threshold and adding it to the original assessed value of $250,000. The new assessed value would have been $1.5 million, resulting in a new tax bill of over $15,000 a year. It's better than the $27,000, but it's far cry from the original $3,000. So many people hear 1 million exclusion and assume they're safe, only to get blindsided by a tax bill they never anticipated and can't afford. If your stomach is churning a little right now, it should be. This isn't about scaring you, it's about waking you up to a new reality. These aren't minor clerical errors, they are permanent, multi-generational financial traps. To help you navigate this, I put together a free comprehensive Prop 19 Trust checklist. It walks you through the exact questions to ask and the provisions your trust needs to address these new laws. It's a simple sanity check to see if your current plan offers real protection or if you're walking blindly into one of these traps. The link is below. in the description. Download it, read it, and use it. So how do you defuse this time bomb before it goes off? The only way to win this game is to get ahead of it. You absolutely, under no circumstances, can wait until after death occurs to start figuring this out. By then, it's too late. First, and this is the most critical point, any trust written before February 16, 2021 is functionally obsolete and must be reviewed. It requires very specific language that gives your successor trustee, the person who takes over after you're gone, the flexibility and power to navigate these rules. It must empower them to distribute the house to the one child who's going to live there while using other assets like cash, retirement accounts, or life insurance to equalize the inheritance for the other children. It needs to have backup plans and contingency clauses built right in. Second, for properties that will never qualify for the parent-child exclusion, like rental properties, vacation homes, or commercial buildings, you need a completely different game plan. The old strategy of just letting them pass through a living trust is now a guaranteed path to full reassessment. Advanced planning might involve using specific legal tools like a family limited liability company, but that's a highly complex strategy with its own set of risks, cost, and tax implication. This is something you should never, ever attempt to do on your own based on something you read online. It requires an expert. Third, paperwork is everything. Meticulous execution is mandatory. When the time comes, the child who inherits this to file a claim for reassessment exclusion, which is Form BOE 19P, and they must also apply for the homeowner's exemption with the county, all within the strict 1-year deadline. And you better believe they'll need to provide proof of residency, a driver's license, voter registration, utility bills, tax filings to back it all up. The burden of proof is entirely on the inheritor. Look, this is not a do-it-yourself project. The laws are a minefield, and the financial stakes are astronomical. The cost of getting qualified professional advice to review and update your estate plan is a tiny drop in the bucket compared to a permanent 5 or 10 times increase in your family's property taxes. The simple promise that you could work hard, build a life, and pass your home onto your family without them being taxed out of it has been shattered by Prop 19 for far too many Californians. A living trust, which for decades was the ultimate shield of protection, can now act as a snare, trapping your family in an inescapable tax burden if it's not properly updated. For the Miller family, the story does not have a happy ending. Their $27,000 a year tax bill is real, it's permanent, and it's growing every year. They are now facing the agonizing choice of paying a bill they cannot afford or being forced to sell a home with a lifetime of irreplaceable memories. But for you, watching this right now, it does not have to end that way. Your story can be different by understanding these common devastating mistakes and taking action now. Not next month, not next year. You can update your plan, protect your legacy, and ensure your family's home remains a source of security, not a source of stress for the next generation. Don't wait for that shocking letter to show up in your mailbox. Grab that checklist below, schedule a conversation with a qualified estate planning professional in your area, and make absolutely certain your plan is built for the world we live in today, not the world of yesterday. If you're feeling overwhelmed with organizing personal assets, handling a property cleanout, keeping up with maintenance, or even need trusted referrals for a CPA or estate attorney, I'm here to help. Drop your questions in the comments or reach out directly. I'd be glad to guide you through it.